Joining me now is the attorney for the family of Bobby Dicello. Is up for the families, Bobby Dicello. Thanks so much for coming on the program. Appreciate it. So I understand that this must be a difficult time for the family. I'm sure there's a lot that I just said you want to respond to. But were you and the family surprised by this decision?
No, we were not surprised, Dan, and we worked hard to brace the family for this result. Ohio has a long history of exonerating police officers who use force in the way that the law would characterize as excessive. And we know that this is not the end of the conversation about whether there will be accountability with respect to this whole thing. I mean, my clients are going to continue to pursue justice. It's just that there won't be criminal charges filed. And you know, as a lawyer, that there's very, very few cases in America today that are getting the kind of scrutiny in the grand jury when police are involved that ordinary citizens get. For example, most of the time, officers are given a chance to come in and tell their side of the story. It's an uncontested story. It's an uncontested presentation in front of citizens who are led to a conclusion. And that's why we say you can indict a ham sandwich. So we were not surprised that there was going to be this kind of presentation. Frankly, I'll just say that if what I saw, because I wasn't there, and the grand jury proceedings in Ohio are confidential, if what I saw looked anything like what the Attorney General presented, it was terribly disappointing.
So you mentioned about police officers being in a different situation. They also have different obligations, right? Ordinary citizens aren't called to go to situations where are inherently dangerous, right? Ordinary citizens aren't asked to do the same thing that police officers are asked to do. And as a result, the standard, I think rightly so, is what would a reasonable police officer do in that particular situation? 8 different officers, right, made the same decision here, which is interesting, right? You could use that against them, but you could also say that that works to their advantage, as the Attorney General mentioned, which is each one of them independently viewed it as a threat, such that they fired between 3 and 18 shots each.
So a couple of things. I agree with you in part, but you missed 2 pieces. The law, according to the big case that everyone should know in this conversation, is Graham v. Connor, 1989 case. It says not only that a reasonable police officer, kind of the abstract, reasonable, objective police officer, is compared to the officer in the field knowing what they know at the time. So would a reasonable officer act like the officer in the case in question acted? That's kind of the thing. But here's the thing. Without 20/20 hindsight, it's actually stated in the opinion, and it's been the law since 1989. So the presentation of the Attorney General was disappointing because it goes back in time to weeks before he even got in his car that night. I have to give you credit because your presentation tonight actually focused on the pursuit and then what happened immediately thereafter. That would be a fairer presentation by anyone's measure than what I saw given what the Attorney General put together.
Well, let me ask you about that because, look, when I had heard initially that he had his wedding ring in the car, I wondered whether this could have been a situation of suicide by cop. I didn't know. I didn't have any evidence to support it. But then you read the prosecutor's report, and it talks about all these Google searches, and this is what you're talking about it going back in time, back to, you know, what happens when you drink bleach, drinking bleach, quickest ways to die. I'm sure from your perspective, that's a sort of a smearing of the victim, but it also does seem to me to be relevant in determining whether there is a possibility that he really did want to die at the hands of police.
Well, Dan, can you show me what's on your phone? I mean, if we're going to do this conversation, you and me, about what's on a person's phone, and we're going to deduce, by the way, the searches were weeks or days before this happened. We're not talking about hours before he got in his car. He searched how to make police kill you. You know, that's not what happened here. More importantly, here's an example that I like to use in this situation. You have a girlfriend, you Google how to break up with your girlfriend, but you stay with her. If she finds your text, should you guys end it? I mean, human beings go through things, and we know that Jayland went through the loss of his girlfriend. We know that made him sad. I said that from day one when this whole story broke. But here's what's being abused and walked past. The Constitution of the United States, the Fourth Amendment, which I took an oath to uphold as an attorney, does not say to the law enforcement agencies that investigated this case, look to see if Jayland wanted to die. Yeah. That has zero, and I mean zero, legal impact on whether a reasonable officer at the time, seeing what he saw, should have done what he did.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.